Welcome back. Inheritance, also called succession, is the devolution of property of an heir or heirs upon the death of the owner. The term inheritance also designates the property itself in modern society, and the process is regulated in minute detail by law. Now, to help us understand this, we're now joined this morning by Ralph Strauss, who is a director and legal practitioner, as well as Rochelle Strauss, who is they're both from Dr. Vierder Kauta and WHK Incorporated. Good morning and welcome, ladies and gentlemen.
Good morning. Thank you for having us.
Thank you for being here. Ralph, let's start with you. Just talk to us this morning about, what exactly is inheritance law?
Yeah, inheritance law is also called the law of succession. Now, the law of succession deals with the devolution of a deceased assets after he passes away. So that means that the law of succession deals with the distribution of the estates of the deceased after death.
All right. And how is inheritance law or the law of succession applied?
Yeah, the law of interstate succession deals with assets of the deceased where the deceased did not leave a last will and testament, which means that there is the assets of the deceased must then be distributed to the heirs without a prescribed wishes of the deceased. So that means that the interstate succession proclamation should apply with regard to the distribution of these assets to the estate, to the heirs. Now, when a person passes away and he leaves a last will and testament, then it means that the wishes of that deceased must be adhered to. Then the assets of the deceased will then be distributed according to the provisions of the last will and testament. That is the estate succession.
All right. Just based on what Ralph just said now, Rochelle, should there be no will and testament, but there are, children of the deceased or family of the deceased who then comes forth and then claims, this property, this land, whatever it may be that is left behind of the deceased person, who then decides how these items, this property, this land, is divided and allocated? Because usually in a will it will clearly say, my eldest son gets 50%, or my daughter gets 15%, or she gets the car, she gets the house, or she gets whatever. But if there's no indication of that, and there are, family members that are left behind, who dictates how, this property is divided amongst, the family?
Okay. Just as Mr. Strauss mentioned now, it will be determined in terms of the interstate succession ordinance or proclamation.
What is that in layman's terms?
What it means that if there's no last will and testament, then the deceased beneficiaries are to inherit from his estate. First of all, you'll have to look at his next of kins. Did the deceased leave a surviving spouse? Any children? If there's no surviving spouse, then you look at the children. If there are children, then his interstate inheritance then devolves upon his children. If there are no children, then you look at his parents. Are his parents still alive? If his parents are still alive, it goes over to his parents. If there are no parents, then you look at his brothers and sisters.
But that doesn't answer my question, though. My question was how much of the property is divided amongst each family member. So his next of kin, he's got a wife and two children, or let's say his wife passed as well, he's got three children, two sons and a girl. Okay. How much percentage of the estate goes to each person? Is it decided amongst the family, or how is that then, resolved?
It's decided in terms of the interstate succession law. Now, if you're looking at how it must be distributed,
yes,
you then check, was the deceased married? How was he married? Was he married in community of property, or was he married out of community property, and did he leave children? So if he was married in community of property, that means that his property, his fixed property, will be distributed equally 50% his wife and 50% is the deceased is the owner.
Aha.
So his 50% share will then be divided between his wife and his children.
Okay, all right. In the instance that there is, no one to inherit the property of the deceased, what happens then?
Okay. You see, if the deceased did not leave a last will and testament and no one to inherit from the estate, then his assets will be forfeited to the state. Now, what happens is if the deceased have had immovable property or movable properties, that properties will be liquidated and the cash will be deposited into the guardian fund of the Master of the High Court. If the funds are not claimed within a period of 30 years, then the funds will be forfeited to the state.
How often do you see that happen, Ralph? That, an individual passes away, they have no next of kin to inherit their estate, and also they've left no will and testament?
Yeah, it's actually a very rare case, and I only, during my practice, I only had one of such a case. And we deposited the funds into the guardian fund, and there's nobody, we couldn't find any family members who could receive the money, so we paid it into the guardian fund. It will stays there until 30 years. If no one claims it, then it will be forfeited to the state.
Is inheritance taxable in Namibia?
Inheritance itself, the money that is bequeathed to any heir is not taxable in Namibia. The estate itself is also not taxable. So we don't have estate duty in Namibia like any other country has. So the inheritance received by an heir is not taxable in the hands of that person.
Let's say that the individual who passed, does leave quite a substantial amount, a cash amount, to be given to his next of kin or whoever his, his dependents were and so forth, and he passes away, but this person also has a lot of debt. What then happens in this case? Is the money then given to the family as per the will and testament, or is it used to settle the debt of the deceased?
Yeah, the debt of the deceased must first be cleared before it is distributed to any heir. So the process is actually that the executor must put an advertisement in the newspaper where he invites all the creditors to submit their claims to the executor within a period of 30 days. Now, the executor will then consider these claims, and if it is a valid claim, then the executor will, during the distribution phase, then settle all the debts of the deceased.
There are a lot of disputes when it comes to the issues of wills and testaments when, a family member has passed, Rochelle. Now, for a person, for example, who is, qualified for an inheritance but is denied for some other reason, what legal route should they take?
May I answer that question?
Yes, please.
Yeah. There may be a lot of reasons why a person is denied his inheritance. Now, that person should actually take it up with the executor as to find out what the reasons are. And if that person is not satisfied with the decision of the executor, then that person has a right to appoint a legal practitioner to investigate and to find out what is the reason that he denies his inheritance. Then if that person cannot afford a legal practitioner, then that person can also just lodge a complaint to the Master of the High Court, and the Master of the High Court will then consider it and then make a ruling on it.
Okay. Can there be an inheritance, Rochelle, when a person is still alive, and how exactly does that work?
Yes, there can be inheritance while the person is still alive. You can decide to pass your assets to your beneficiaries while you're alive in a form of a donation of the immovable property, or where there is cash available, you can distribute your cash to your beneficiaries.
You spoke a lot about an executor of the will, and I understand the role that they play. But in an instance, because a lot of time family members don't go to, to lawyers, professional lawyers, to have their wills drawn up, as unless a oom of a broer of a lawyer is, and they ask, family members to just draw this up for them, and that is their will, and that person then becomes the executor because they've written up the will on behalf of the individual. But in the instance that an executor then passes away, and there is no executor of the will, what happens in such a case?
Yeah, then the family members, they must come together, and then they must nominate an executor. Now, the surviving spouse of the deceased has the first right to be appointed as the executor of the estate. But if the children, for instance, feels that they're uncomfortable that the surviving spouse should be appointed as the executor, then they can also nominate someone or one of the children as the executor. And then they should send the nominations through to the Master of the High Court. And the Master of the High Court will then decide whether to appoint that person as the executor or not.
So quite a process then.
It's quite a process. That's why it's very important to have a last will and testament, to nominate your executor in the last will and testament, so that there are not fighting and disputes afterwards who should be the executor of the estate.
Rochelle, can someone inherit the property of a deceased without a valid will? Does it go back to what you mentioned earlier in terms of looking if these people were married in community of property or not? Just explain that process to us. If there is no will, what happens?
It is considered as an interstate distribution. Interstate meaning that the assets will be distributed to his surviving spouse, if he had a spouse, or to his children, biological children.
All right. Well, any final remarks you'd like to add for us on this topic? I think it's quite relevant in these times that we're living in, and a lot of deaths happening, unfortunately, due to the pandemic. So this is something that people really need to have information about. Would you like to give us some last remarks before we go?
Yes, I would like to emphasize the fact that it's very important that each one of us should consider drafting a last will and testament, just to make sure that your wishes are then adhered to at the end of the day, to make sure that the correct executor is appointed, to make sure who should get what, and that there are not any disputes at the end of the day. So that is actually very important. And then estate planning should also form part of a person's decision-making process. So they can go to a legal practitioner or any estate practitioner and ask them for assistance into estate planning or to draft a last will and testament.
Just in a nutshell, what does estate planning entail?
Estate planning is just to make sure that the heirs at the end of the day does not sit with a lot of debts. And when there's a debt in the estate, which is more than the assets of the estate, then the asset is actually insolvent. And there are two ways to deal with the insolvency of an estate. But at the end of the day, the heirs are responsible for any cash shortfall in the estate of the deceased. So the estate planning deals with to make sure that all the assets that you have are duly covered and that there are not a lot of debts that will eat up your inheritance.
So in essence, you can also inherit debt, not just assets.
That's correct.
Rochelle, any final remarks from you?
No.
All right. Well, thank you so much for being here this morning, and thank you for your time.
It's a pleasure.
Thank you.
That was Mr. Ralph Strauss, who's the Director and Legal Practitioner at Dr. Weerder, Kauta and Oveka, alongside Rochelle Strauss, who's the Legal Secretary also from the same law firm. We were talking about the inheritance law.